In light of recent events in June 2022, it is important to discuss judicial review in context of Roe v. Wade. As you have already read, Marbury versus Madison has established judicial review. This allowed the Supreme Court to rule on additional cases that could have national significance. Before Roe v. Wade came to the Supreme Court in 1973, abortion was legal based on the state that you reside. Abortion was essentially a state-by-state issue, and it was deemed as states' rights, such as reviewing the 10th Amendment. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectfully or to the people. Because abortion was not written in the Constitution, individuals believe that states should solely decide if abortion should be legal. Yet other cases, such as Griswold versus Connecticut in 1965, began to question the validity of women not being able to access reproductive health care in their own state based on their residence. The Supreme Court ruled that it violated the 13th Amendment for women to not be able to have access to birth control. Roe v. Wade was essentially asking about personhood and privacy. This became the 4th, 19th, 13th, and 14th Amendment issue. The two foundational questions are, number one, what obligations does the government have to its own citizens? When does a person become a citizen? Thus, who deserves more protection, woman or fetus? Number two, when does personal privacy begin and end? Does pregnancy deny women personal choice, or is it the government that can legislate personal choice? These questions were decided in Roe v. Wade and continue to be legislated based on viability of the fetus. The government must protect the fetus if it is viable to live outside of the mother. The mother has a choice up until viability. This means that first-term abortions have been widely supported by the public. It is the second-term trimester that has always been debated. At the time Roe v. Wade was decided, a fetus had not lived beyond 6 months. Now, with better science, this has been moved up significantly. We are now in the age of the Supreme Court overturning Roe v. Wade. This case is named Dobbs versus Jackson Women's Health Clinic. Clinics have began to prepare for what will happen in states that already are prepared to ban abortion. In California, Governor Newsom has already passed laws to protect abortion, but to also provide funding and safe passage for women who travel here to obtain an abortion. We must remember that Roe v. Wade was decided in the middle of the women's movement. Women wanted more agency over their body and future. There were many other lower courts where court cases where women could work as a lawyer, keep their last name, have birth control, receive a paycheck in their name and not their husband's name, etc. For many, Roe v. Wade was a victory. In contrast, Dobbs v. Jackson is being decided in a time where anyone under 49 years old has never had to consider that abortion was illegal. In fact, almost 70% of Americans favor abortion within the first term, 1 to 9 weeks. So the Supreme Court decision is not aligning to the public sentiment. The draft of the Dobbs v. Jackson is available and I will provide it for you. I will do another in-depth lecture on the decision when it is finally decided. This decision is not only important and impactful to millions of girls and women around the United States, but it's also has an impact on the idea of legal precedents. It is not often that the Supreme Court overturns a precedent. This act has caused legal scholars to consider the safety of other precedents pertaining to gay marriage, interracial marriage, school integration, and others that protect the rights of minoritized people.